Hi everyone, my name is Oroma Reynolds, and I am the founder and owner of a special needs law firm called MSR Legal and Consulting Services based out of New York. I am also a blogger, and I blog about recent developments impacting children with special needs, particularly in the area of education. So I quickly want to draw your attention to tonight's blog post. If you toggle on my website, which is www.msrlegal.org, to the link to special needs parenting in the coronavirus pandemic, you will see tonight's blog post about the recent U.S. Supreme Court decision on the extent of student speech being protected by the First Amendment, and in particular, speech or expression that takes place off campus. So this is like your Snapchat, Instagram, Facebook, social media happening off of school grounds, on the weekends or after school, and whether a student can be punished for that or can be disciplined by the school. So I encourage you all to read this really brief post and contact me if you do have questions, or if your child is either a victim of hateful speech, or if your child has been identified as an aggressor, and your child's special education needs have not been met by the school district. I have a button over here, book your virtual consultation. And when you fill out this contact form, you'll be able to request and possibly receive a consultation via email, which I think parents who are just looking for information and information about whether they do have a case and whether MSR Legal is the right firm for them, can also make that inquiry on this contact form. So going back to my blog post about this U.S. Supreme Court decision, it's not necessarily groundbreaking in that the rule has typically been that unless your speech disrupts the learning environment, it is protected, and that a student doesn't lose their right to freedom of expression under the First Amendment just because they're a student within a school. But what this decision does do is talk about, why the justices ruled in one particular way in favor of a student who participated in off-campus speech and was punished for that and was kicked off of her cheerleading team. So definitely, if you have questions about this decision, reach out. It's really important to note, and I do that in my blog, that a speech that is considered bullying or harassing in nature is not protected. So definitely, if you're on either side of this issue, you should know that you do have rights. There are a number of rights afforded to children who are already designated as having a disability, or who are suspected of having a disability and engage in conduct which is considered an infraction of the school disciplinary code. So again, this is where you would book your consultation, this little purple button. Consultations are available via email for efficiency purposes. So this is my YouTube channel, MSR Legal Oroma. I'm hoping to do this every Friday evening, highlighting a new topic, hopefully a timely topic in the world of education policy, with an eye towards how that update or development or evolving practice impacts parents of children with special needs. until next time, have a great weekend, have a great week, and thanks for tuning in.